Good morning, Ms. Bailey.
Good morning.
We have Commissioner Giraldo,
Good morning.
Commissioner Washington,
Good morning.
and Commissioner Dorner.
Hello.
Please note that the deadline for all participant pre-registration and for all submission of materials and exhibits was 12 noon on the Tuesday before this planning board meeting. Registered speakers can join the meeting with a link provided in the email provided by the planning board office or listen by phone by utilizing the call-in number, which is also provided. And of course, you can watch via live stream with the information that you see before you on the screen. In addition to the commissioners, we are joined by Mr. Warner, our principal counsel. Good morning, Mr. Warner. We have Jessica Jones, our planning board administrator. Good morning, Ms. Jones. And Joe Parsons, our senior technical hearing writer. Sherry Connor, acting development review division chief. And thank you, as always, to Ryan Cron and Kenny Flanagan for helping us with technology behind the scenes. As we begin the day, and I don't think it's going to be a very long day, but I want to start off with some difficult news for us. I'm going to steal Commissioner Dorner's thunder. I want to announce to the public that, unfortunately, a loss to the county. Commissioner Dorner will be stepping down from the planning board, stepping down as a commissioner effective, I think it's the 13th is the official day. And I imagine there's lots to say, and I want to make sure, Will, you get a chance to say some things too, and the rest of my colleagues. This is kind of short notice, but we'll make sure that we'll have an opportunity to fetch you, to celebrate you properly down the road for the 9 years, I believe, of incredible service to the county, to the commission, to the planning board. From my perspective, you've been an absolute pleasure to work with and helped educate me, and somebody who I feel like I can count on and the community can count on, and it's been a great service. So I want to just give ourselves a few minutes. Colleagues, those of you who served with Will longer than me may have some things to say as well. And again, this isn't going to be our only chance, but I don't want to let this go without marking the occasion.
I could go first. I want to thank you, Chair, for giving this opportunity. I've been on the board the entire time that Will has, and I can tell you, one of the things that impressed me most about him was what a great father he is.
Mm.
And I mean, he did great work on the board, but that is one characteristic that I always admired in him, and it was just warm to my heart. I really appreciated Will's comments, especially when it came, and it was small things. For example, he was the first one to raise with the new developers or builders to put enough space in the door frames in the front so they can install a Ring camera.
Huh.
Not something that I ever thought about, but when he did, I say, you know what? That makes a lot of sense. And so I thank Will for that. I also thank him for being such an advocate for the physically challenged, and that really came to light when the developers would come in and they would have a recreation area, and Will would basically insist that they need to do some activities that would can be accommodated by all children, irrespective of their physical challenges. And Will, so I thank you for that, because that's not something that's considered. And you, because you have a personal history there, that enlightened me in terms of the importance of making activities available to all. And as you know, we've Maryland National Capital has gotten awards in the past for being that conscious of children and adults with physical challenges. And now, because of your influence, now the developers are seeing that too. So, Will, I really appreciate your participation in the commission. It's been elucidating for me in terms of the areas that you spoke about. I wish you the best, and I can tell you this: don't take the buyout.
I
I just want to jump in and kind of double down on what my colleague, Commissioner Giraldo said. And he said it really well. And Will, you definitely will be missed. I think just to summarize kind of what Manny was saying, you approached your work as a commissioner through your lived experiences. Yeah. You know, being a great dad, your kids, even the Ring doorbell scenario that Manny talked about. You know, I think it was because of something you had experienced in your own life, and that really was helpful. And I think it added a lot to. I know it added a lot to your deliberations as part of the planning board. And I thank you for that. And I thank you for your friendship. You know, I think all of us are uniquely situated where we come to this table with very different lived experiences, but we are genuinely interested in each other's lived experience. And I think that makes for a better process. Certainly, hopefully, better outcomes for the community. And I won't say goodbye. I'll just say, gonna miss you on Thursdays. But let's definitely stay in touch. And I look forward to the in-person celebration of your time and tenure on the planning board.
And I want to just add a few comments. I think my colleagues have said everything that I was going to say. And I'd like to just, if it was a motion, I would second it. But it's been my pleasure to listen to you, Will, to learn from you, to work with you, and just to get to know you. It has been a delight and a joy. Sometimes I would wait for you to make a comment before I made a comment because I want to know, what is Will thinking? What is he going to say? But you will be missed. And certainly I look forward to celebrating you and staying in touch with you. I sent you a note and said, I do have your phone number. And you will soon have mine. So take care. And I am definitely going to miss you and wish you well.
Yeah. Mr. Dorner, thoughts, comments, reactions as you wind down this chapter of your life?
Well, hopefully it's not winding down completely.
No, just a chapter.
Yeah, and I'll continue to be involved in the community and development of different things, probably in different capacities. Who knows where it'll lead? But I want to thank all of you for your kind words. It's been a pleasure to serve in this role on behalf of the residents, but also sitting next to all of you. I think it's absolutely true what Commissioner Washington said and what Commissioner Giraldo were highlighting in terms of, like, we all come from this or bring to this role different sort of perspectives based on our own unique backgrounds, life experiences, and trainings. When I first started the board, I had a brand new son, but I didn't have my daughter. And he was just literally just born. He was born in August, and I started this in November. So it's actually been a little bit over 8 years, not quite 9. But that changed a lot of the perspective that I brought. When I first began, it was coming off of the City of Hyattsville's planning committee. And I was just really happy to be involved with that. I'd been involved with county and state stuff when I was in grad school and doing some consulting work. And I'd taken land use regulation courses in the law school because I just thought it'd be fun to do. And it was probably not the best life decision at the time because I hadn't taken any of the L1 courses. So I was thrown in and had to quickly get up to speed on a lot of things. But that gave me a really interesting kind of background. And I always thought it was just fantastic to be able to be involved in the community because of my sort of technical or kind of nerdy like background in some of these things where I really like this stuff. It's what I do from like a professional sort of training. And the local aspects that we go through and we touch every week are just fascinating cases for me to bring back to my federal job and think about how does that change the policy stuff we're working on? How does that inform some of the research that my team is doing and have a really nice kind of intersection of those things, particularly because our county does so much. That's been really helpful to think about how do we influence things at a federal level, not just for like bigger counties or different things to that nature, but what are we missing and what are we not thinking about because we're not involved in the day to day and we're not at the federal level. That has really made my ability to serve it as a civil servant in my other capacity even more informed. And that's been really, really useful to bring in. So I've enjoyed the experience to inform my primary job, but then also just to be able to make an impact on the community and make it better. As all of you have heard and know, I use the trails and the parks quite a bit. I'll be at one of our facilities on Saturday for some other events with my son for some of the classes he's taking. We involve them in swimming and gymnastics, and now he's doing this drawing class. So we're fully engaged with the Department of Parks and Recreation, not just on the planning board side. And it's those experiences and kind of just seeing some of the user experiences that have made me reach out to the people on Parks and Rec and think about like how do we make stuff just a little bit better for people that are experiencing this in different ways. Not to say like there's problems, like it's just when people come at it, like everyone leaves a great impression. Everyone improves the county in different ways, whether it's on the planning board side or the Parks and Rec or different things that we're able to touch. And I've just been very fortunate to be in the seat where I'm experiencing a different moment than what other people may, and I have the opportunity to raise concerns or to raise things to improve it for other people. And I feel blessed to have that opportunity. And I'm hoping that it'll continue. There are other things that will hopefully live on beyond my time that I had here to be permanent kind of changes in how we do things. And if that happens, then I would be fantastically pleased at having spent the time here and being able to do that, because I think working with all of you and working with the staff has just been such an awesome opportunity over the past 8 years. And I'm very happy to have been able to do that. And it's fun going out in the community and seeing some of the people in the Parks and Rec departments or the planning departments in different capacities and interacting with them and kind of hearing what they're doing and then being able to help improve things when I come back to the commissioner role. I never started this job thinking that I was going to be on it for more than a couple of years when I was filling in the temporary role, and it's just sort of continued. But I think there's every job, every opportunity, everything we do in life, there's always change. There's always going to be opportunities for new people to come in, and there's always going to be a limit in terms of when we can make and impact people's lives or help people out or do things. And this is just in this particular phase of life for me, the conclusion of that in this particular capacity, but hopefully not the permanent conclusion in different ways. So I am very happy to have had this chance and very glad to have worked with all of you and very glad to have worked with the different developers and attorneys. And I mean, to them, I also am very grateful because I would reach out to some of them about different things on their cases afterwards and stuff and say, hey, really great job on this and stuff. And it's just nice to see them in other capacities down the road and to see that. So I'm really just happy to have had the experience and just to see the citizens too. It's been really rewarding to see so many people getting involved over the past few years in their communities and asking for things in cases and making us think about how they are living in their communities and how that affects them. So we can take all of those into account. And then I just also want to end on, in the budget hearings that we've had as well, it's been fantastic to see all the different people coming and talking and stuff within there, to see the children that have done that. We've lost some people recently and just some unfortunate accidents, and it's going to be a huge loss for the communities, for the youth that were involved, and that made really good impressions. So I'm hoping we can continue to build upon things that they've brought up and that they've indicated are important to them. So that way we don't forget that as we're sitting here and hearing real estate cases every day, that's extremely important. To be able to create affordable housing and sustainable housing and improve the housing supply is extremely important in the day-to-day. But we also need to think about how do people experience the community in other ways, and when they're raising concerns, make sure that we're addressing them. So I'll end on that note, and we have work to do.
We do indeed. Wonderful words. Thank you for everything. Thanks for the impact that you've had for so many people in the county and your community. Thanks for all of your leadership as you just elucidated in all the different ways. And we will see you on the trails and in the parks. So thank you. Thank you, sir. And again, there'll be more formal festivities as time comes along, but thank you again for all of your service. All right, folks, anything else to add? Then let's move on with the agenda. And if something bubbles up and you have something else you want to say about Will and his bow tie down the road, feel free. I know, Manny, that's going to be hard for you to be the solo bow tie, but it's okay. You'll manage.
I'll be the sole bow tie.
Exactly. So let's move on to item 2 on our agenda. Look for a motion to approve the draft minutes for January 30th, 2025.
Motion to approve draft minutes.
Second.
And a motion by Vice Chair Bailey, a second by Commissioner Washington. With no discussion, I'll call the roll. Vice Chair Bailey.
Vote aye.
Commissioner Washington.
I vote aye.
Commissioner Giraldo.
I vote aye.
Commissioner Dorner.
Vote aye.
I vote aye as well. The ayes have it 5-0. We'll now move on to supplemental item 3A, legislative updates. Do we have Ms. Borden on the line? We do. And I believe we have 2 legislative items, or 3 actually, 3AB and 3A1, A2, and then 3C. I don't know what that means math-wise, but anyhow, we have 3 items. Ms. Borden.
Well, I only have 2 bills, so I'm not sure what the other item is. But I can go through my 2 bills fairly quickly.
Oh, you know what? I'm sorry. You go through your 2, and then we have Director Hull who will be talking about item 3C. But
Okay.
go ahead, Ms. Borden.
Thank you. Good morning, Mr. Chair and members of the Planning Board. Deborah Borden, General Counsel for the record. And let me just say, having worked with Commissioner Dorner for all of his time really on this board, I will absolutely miss Professor Dorner. He is a wonderful person to work with, so knowledgeable. And, as the legal department, we love people who know what they're talking about. We love that. So we will miss you so very much. So I will get right to it. I have 2 bills for you this morning. They're pretty simple bills. So HB 724 is entitled Commission on Abandoned and Neglected Maryland Cemeteries. And it is establishing a commission to generally deal with, review, track abandoned and neglected cemeteries. So we have a couple of comments about this. We do have a long history of working with cemeteries in all kinds of conditions, historic cemeteries in particular, and we have that history in both counties. So we do have some information and some considerations that we think that the committee should look at. One is that throughout the bill, neglected and abandoned are used interchangeably, even though those are really different concepts. So we're suggesting that they delineate what they mean by those 2 terms. There's also some unclear language in the bill about establishing a statewide inventory of cemeteries. It's a little unclear as to whether this database would be established by this new commission or whether they're proposing that an existing agency should establish this. It's not clear who would be doing this work. We also have a suggestion that they include on the membership of the commission, this new commission, the Maryland Historical Trust, who is also known for working with historic cemeteries and providing information and guidance to various groups on that over the years. So we suggested that, and we also have heard from the Maryland Historical Trust, who also wants to be on the commission. So with that, we are proposing an informational sheet only, and I'm happy to answer any questions about that.
Thank you, Ms. Borden. Questions?
Yeah, not a question. Well, thank you, General Counsel Board. And just one thought, and I don't know if this was contemplated as part of your suggestion regarding the Maryland Historical Trust, but oftentimes it will come up when we're hearing cases about certain developed properties, and there may or may not be remains from enslaved people or persons. I don't know that that constitutes cemetery, in a literal sense. But if there's some way that that can also be maybe incorporated in here to look at, because it would be great if they're building a database to ensure that those type properties are included.
I actually think that that is the impetus for this move, to create a database. Yeah, because there have been several high profile issues that have arisen with cemeteries or burial grounds, whether they're officially cemeteries or not, that have contained historical burials that have then been in conflict or on ground that's supposed to be developed, or that is in danger because of road widening. That's a big thing. And so I think this is on a lot of legislators' radar, and they're trying to find different ways to address this going forward. So I think this is yet one more attempt to do that.
Great. Thank you very much.
I want to follow on what Commissioner Washington inquired about. So, is there a definition? I didn't see one of what is considered to be an abandoned and a neglected Maryland cemetery. And I was thinking whether or not in our position statement we should make it known, just what Commissioner Washington said, that this would include other types of burial grounds that may not have been classified as such.
So, the term cemetery is certainly defined. I don't have it in front of me, but it is defined. The abandoned and neglected part is not defined, and that's what we're suggesting, that they need to define that. So, generally speaking, whenever you have a burial, it doesn't have to be a full-blown cemetery with multiple burials. Any burial, that is discovered in the process of developing a property then triggers all kinds of procedures that have to be followed in order to deal with those remains. So those processes are already in place and have been in place for decades. The issue that really is being discussed a lot now and is at the forefront is these historical burials that are either historical because they are formerly enslaved people, they are in some way related to the history of the founding of the state, of the colony that then became the state of Maryland. And the issue is that since we don't know where all of these are, and there is no central database for these, particularly these historic areas, it becomes very difficult for people to know and then have their voices heard when these processes are taking place, because the process usually goes through the state's attorney or the county attorney for that county. And, there's notice, but sometimes they can't find the people to notify. It can be a difficult thing to find out about. And so the idea is if you have a database, people can track these, they know which ones are in their area. And if something were to happen, like a development that's close to that, then they can spring into action. Right? They have more knowledge about what's happening, but the processes are already in place for a burial that then, is impinged upon by encroaching development. That's already in place. Did that answer your question?
It kind of, sort of. I'm just concerned more with that that the abandoned and neglected is, as you say, is not defined. And I would like to see, because you know the way legislation is, if it's not specifically stated, somebody could say, well, the legislators were looking at it and it's not included, so therefore. So I think we need some reference to make it clear that this would also apply to burial grounds that perhaps were not classified as a cemetery or as a cemetery. That's all.
Okay, we can absolutely add that to our information sheet and make it clear that we are suggesting that they need a definition for abandoned and neglected.
Okay, thank you.
No problem.
Other questions? Okay, this is information only, but you have heard the comments from my colleagues. I think we're all in agreement with those suggestions from our side, unless I hear otherwise. So the information on the goes out and will reflect that accordingly, I assume.
Yes.
And then we got one more item.
One more, that is SB 834. It is entitled Prince George's County District Council Zoning Laws Override by Municipal Corporations. We received this bill 2 days ago, and we did not have any prior information about this bill. We weren't expecting this. So this bill is rather unusual because it purports to authorize all municipal corporations, all municipalities in Prince George's County to, by majority vote, override anything in the zoning ordinance for the county. So that is concerning. I'm sorry, did I say 834? I meant 832, SB 832. So that is concerning, obviously, because that would basically negate the county zoning ordinance within the municipalities, or it has the potential to nullify the county zoning ordinance without giving the municipalities authority to do zoning themselves. So in other words, it gives the municipalities the opportunity and the authority to say no, but it doesn't give them the opportunity or authority to say, well, what do you do? So that's a problem. We understand that these bills often come up because someone or someone's constituents are upset about a particular development project that they didn't like or that they didn't think was in the right place. We understand that happens. And I do think that that's probably where this is coming from. Mm-hmm. So while we have sprung into action and tried to pull together some talking points about why this is a problematic bill, we wanted to make sure we got that because, frankly, it came up very quickly. And the hearing before the committee was last night. So we had to do something very fast. And so these are the talking points that we submitted to them last night. We did tell them that you hadn't taken a position on the bill, that these were staff comments only. But we had to get something in because we couldn't give the committee the impression that this was in any way okay. But what we propose to do is to reach out to the sponsor, discuss with him and anybody else on the committee, the reasons that he is concerned, and try to work on some suggestions that would actually work. Because this suggestion, this bill, as written, really wouldn't work. It would break zoning, but it wouldn't do, I think, what he's looking to do. I think he's concerned about some uses, and there may be some other things that he's concerned about. So we can talk about that, talk it through with the sponsor, but we definitely still need to, I think, oppose the bill. So I'll stop there.
Thank you. And Commissioners, just a bit more information. I have had the opportunity to speak with the sponsor, and what Ms. Borden is saying is what's driving this. It's just, what are considered noxious uses and what can we do to beef that up. So we're in conversation. There's a good chance that I'll actually be speaking before the Senate delegation next week, and this will be one of the primary conversations. So as we all know, these things come up almost every year in some way, shape, or form. But just a heads up, and I agree with the recommendation from staff, clear as day, as written. I am fully in support of opposing this, even while we are in conversation around what are some potential solutions.
Mr. Chair, who's the sponsor? Or
Senator
sponsor?
Charles. Nick Charles.
Who?
Nick Charles, Senator Charles.
Okay. Okay. Okay, thank you.
So
Well, I kind of agree with you, Mr. Chair, with regards to that. I mean, I think it would wreak havoc throughout the county if the municipalities can just undermine the zoning code all the time that we put into it, developing a new zoning code for the benefit of the residents and developers, and would create a great level of uncertainty. But thank you.
Yeah, agreed.
So I'm in support of the position for sure that we're taking on this. It might help if we are, and you may have already done this, but if we're empathetic to his concerns on the sense of if we have a totally dysfunctional county council who can't agree upon certain things or vote in a particular way, like on affordable housing and ADUs and things that we need that local municipalities want, it would be hard for them to otherwise pass this kind of legislation. So I'm empathetic to his aim on this, but I think that there's all sorts of other things that would be problematic coming out of this. And I know, Ms. Borden, that you've written this from a high level, like easy to kind of digest bullet points. This has severe legal implications for Dillon's rule. And there would be all sorts of legal cases. It has no timeline of how far back they could go. This could completely uproot in terms of how zoning is done and where police powers are inherited and how those are exercised. So I think fundamentally, like, you could end up at the Maryland Supreme Court with this kind of stuff later on, and even higher, just because like he's not even thinking about how this changes and preempts like how powers are bestowed to different groups, and this could be really problematic to figure out like how we would implement this and adjust. Like it'd be one thing if he was looking to give home rule to a particular municipality and allow independence from that, which is also, I would say it's within his authority to do legislatively, but isn't a great choice all the time to make. But to completely usurp the county council's ability or the district council's ability to pass code, and then the municipalities have to abide by that, really changes the dynamics of how this is done. And this would affect the entire state, which would just make it very, very problematic from a legal standpoint. I'll just stop there. And I don't know how you want to like kind of frame that, but I think that could also be some of our more technical aspects. It's not just about developers or uncertainty. So you're gonna get full of cases. People appealing because their vested rights have been undone, or they're close to getting vested rights, and that has been changed. But then also B, just like philosophical legal challenges to this are just going to be extensive.
Yeah.
Yeah.
Agreed. Well said.
I think this is more politics than policy. And with that, Mr. Chairman, I would move that we oppose SB 832.
Second.
Got a motion by Commissioner Washington, a second by Commissioner Giraldo. No discussion. I will call the roll. Commissioner Washington.
Vote aye.
Commissioner Giraldo.
I vote aye.
Vice Chair Bailey.
But I.
Commissioner Dorner.
But
I vote aye as well. The ayes have it 5-0. Thank you, Ms. Borden. Thank you, Ms. Balcom-Colbert. We have item 3C on our agenda, data center study, and I'll turn to Director Hull on this item.
Good morning, Commissioners. Commissioner Dorner, I haven't had a chance to work with you much in my year in this role, but I do want to acknowledge that you are part of the board for approving the permission to print for Go Prince George's. So please stay connected with us, because we're going to have a strong advocate to make sure we have good bike facilities and trails throughout the county. So thank you for that. My update is in regards to data centers. So we know that's a polarizing term. The interesting thing is where we are right now in the county is that we have a lot of different perspectives on data centers. And so I've recently worked with various parties. I was at a roundtable discussion, and it's very important as a county and as a planning entity that we take more of a lead in how we're looking at data centers in a strategic way. We know that there's demands on data centers in regards to energy, water, sewer, public and private utilities, environmental impacts, and also just the tax revenue side of things. Last year, we saw that the governor signed the Critical Infrastructure Streamlining Act of 2024, where he was able to give approvals to install backup power for generators for data centers. We know Prince George's County Economic Development Corporation also has a data center map. And so as we're looking at all of these different things together, we also have our county council that also looked at legislation last year on this topic. So we're trying to make sure that as we're having a collective conversation, that we have the right tools in place. So I'm asking for the planning board to support and recommend the ability for the planning department to do a study on data centers, to do a deeper dive in some of the issues and concerns, and also look at some of the case studies. If we've noticed, Loudoun County has had some challenges. Prince William County has also dealt with their pros and cons. So how do we look at regulations? How do we look at infrastructure capacity? How do we look at noise, access management, adjacencies? So that's the goal for the planning department, is to spend some months until the fall to do some study and analysis and to provide a report on some of those best practices and potentially next steps in moving forward really sound legislation. So with that, I will open up the floor for any questions, feedback, or any suggestions of what you would like to have in that study as well.
Well, Ms. Hall, the only concern that I have, well, there's a couple of concerns, but one of them is how long will the study take? Only because, put it this way, the county right now is in a $170 million deficit, okay? We know from looking at Prince William County, Loudoun County, Fairfax County, that the data centers are a big source of income and revenue for those counties. And one of the things that are affecting our budget, meaning the county budget, is because unlike Montgomery County or Northern Virginia, our taxpayers represent 70% or thereabouts of the revenue generated for the county's budget. Whereas Montgomery County, even DC and Arlington and Alexandria, it's reversed. Commercial brings 70% of the tax revenue, and 30% is for residents, by the residents. So I really do want to see the study. I would like it to be expedited. I think we have a lot of property within the county that could be used for data centers, and I don't think we're not going to invent the wheel. And so I like the idea that you're going to compare or look at the best practices for Fairfax, Loudoun, Prince William, and the like. And I would just like it to be an expedited process so we can move forward and begin with these data centers. Thank you.
Definitely, sir. And so in the resolution, we're requesting for all the research and study to be completed by September 1st of this year, 2025. So that means I will not be going on vacation this year. I have made this a priority because we're going to need to have the PEPCOs at the table. I think that's the biggest thing that we're seeing, is that do we have the capacity for some of these sites? The other thing that we know, we have some environmental concerns with some of the potential sites. We want to make sure when this does come back before the council, hopefully in the fall, they can have legislation that we can all move on. We did a site visit last summer on some data centers. One thing we learned from one of the counties is that data centers have to have a certainty to move forward within a 6 to 9 month period. Mm-hmm. They pretty much want to have that vertical ability to build their data center quickly. And so our legislation also has to be mindful of that timeline as well.
Thank you.
Excellent. Other thoughts, questions, reactions? If not, I would look for a motion to approve staff's recommendation for the data center study.
Move approval, Mr. Chairman.
Second.
Got a motion by Commissioner Washington, a second by Vice Chair Bailey. No discussion. I'm sorry, under discussion. This is going to be in the form of a
draft resolution.
A resolution. It's going to be a resolution from the council to us. We're essentially drafting their resolution to us to do the report.
As I understand it, yes.
Okay, all right, great. No further discussion. I'll call the roll. Commissioner Washington.
I vote aye.
Vice Chair Bailey.
Vote aye.
Commissioner Giraldo.
I vote aye.
Commissioner Dorner.
Vote aye.
I vote aye as well. The ayes have it, 5-0. Thank you, Director Hull.
Thank you.
All right, consent agenda items. Anyone who wishes to oppose staff's recommendations on item 4B, or any board member wishes to discuss the item? If not, I would look for a motion.
After consideration of after consideration of the items on the consent agenda, I move adoption of the findings on the consent agenda in accordance with the recommendation of staff.
Second.
Got a motion by Vice Chair Bailey, a second by Commissioner Washington. With no discussion, I'll call the roll. Vice Chair Bailey.
Vote aye.
Commissioner Washington.
I vote aye.
Commissioner Giraldo.
Vote aye.
Commissioner Dorner.
Vote aye.
I vote aye as well. The ayes have it, 5-0. Move on to regular agenda items. Item 5 on our agenda. This is a preliminary plan of subdivision 4-23015 Loveland. Mr. Rivera is representing the applicant. Ms. Vandus is going to be giving a staff presentation. This is a evidentiary hearing. If there are folks who are testifying beyond the applicant representative, we'll swear them at the appropriate time. I think there is some opposition on this as well. Let us start with staff for the presentation. Ms. Fatnus, good morning. Take it away. The floor is yours.
Good morning. Sound check. Can you hear me?
We can hear you. You're a little choppy.
Is it better now?
Yes, it's better now.
Okay. Thank you. Good morning, Mr. Chair and members of the board. For the record, my name is Mahsa Vatandus with the subdivision section. Item number 5 on the agenda is a preliminary plan of subdivision for Loveland 4-23015. The subdivision proposes 8 lots for development of 8 single-family attached residential units. The preliminary plan is supported by an approved certificate of adequacy ADQ-2023-026. Before I begin, as a matter of housekeeping, there are 6 exhibits in the additional backup for this case, which were submitted prior to the noon deadline on February 4, 2025, which will be discussed further in my presentation. Next slide, please. The site is located in the southwest corner of Properties County on the Prince George's County within Planning Area 76B and Council District 8. Next slide, please. More specifically, the site outlined here in red is located at the terminus of Arden Lane and Lumar Drive, approximately 265 feet southeast of Allentown Road. Next slide, please. The zoning map shows that the site outlined on this slide in red is zoned residential estate zone as shown in the image to the right. This preliminary plan of subdivision was accepted for review under the prior zoning ordinance and subdivision regulations. Under the prior zoning ordinance, the site was still in the residential estate zone as shown in the image to the left. Next slide, please. The site map shows the site outlined in purple and indicates the topography on the site. Next slide, please. This photo shows another view of the site from an aerial perspective. The site is currently wooded. The property is bound to the southwest and northwest by single-family detached dwelling units. The public right-of-way of Arden Lane terminates at the northwest edge of the property boundary. To the north lies the unimproved right-of-way of Lumar Drive with vacant land beyond. To the east and southeast lies wooded, undeveloped land. Next slide, please. The master plan right-of-way map shows that the subject site is not adjacent to any master plan rights-of-way. Next slide, please. This preliminary plan of subdivision proposes 8 lots for 8 single-family detached residential units. This overall view of the preliminary plan of subdivision shows the layout of the proposed lots in red. public rights-of-way, Lumor Drive and Arden Lane in purple. Also, the property is associated with primary management area shown in blue dashed line on the southeast corner of the property. The property fronts on Lumor Drive. However, the preliminary plan proposes the extension of Arden Lane and its termination in a cul-de-sac. The extension will serve all the 8 lots and will provide adequate circulation to the site. Staff find that the vehicular access and circulation for the proposed development to be sufficient. Next slide, please. This application is subject to the 2024 Woodland Conservation Ordinance that came into effect on July 1st, 2024. The Type 1 Tree Conservation Plan shows the property boundary outlined in red, public rights-of-way in purple, primary management area in the blue dashed line. Impacts to the PMA impacts totaling 0.42 acres are requested with this subdivision and are highlighted in pink. These PMA impacts are requested for construction of a sewer line connection, storm drains, stormwater management outfall, and utility connections. The 2 requested PMA impacts and staff analysis are further detailed on pages 26 through 28 of the technical staff report. The proposed on-site woodland preservation areas are highlighted in green and reforestation area is highlighted here in dark green. Woodland preserved but not assumed cleared are shaded in light green color. The applicant has requested a variance from Section 25-122B1G, which requires preservation of specimen trees. This preliminary plan of subdivision proposes removal of 7 specimen trees on site, the location of which are shown by green circles and orange crosses on this slide. These trees proposed for removal range from good to fair condition. This variance request is discussed further in the environmental finding on pages 24 to 26 of the technical staff report. Also, the applicant has requested a variance from Section 25-121C3 for not providing the woodland conservation threshold on site. Per the requirements of Section 25-121C3, amended by Prince George's County Council Bill CB 20-2024, this project is required to provide 2.44 acres woodland conservation threshold on site. The applicant proposes 1.73 acres of woodland conservation on site, which is 0.71 acres short of providing the 25% required woodland conservation threshold on site. Staff finds that the required findings of Section 25-119D have not been adequately addressed for not providing the woodland conservation threshold on site and does not support the applicant's request for the variance based on the findings which are discussed in the environmental findings on pages 19 to 23 of the technical staff report and recommend the condition of approval to provide the 25% woodland conservation threshold on site, which may result in the need to adjust or remove lots. Next slide, please. Staff has received 6 exhibits shown as additional backup for this preliminary plan. Pages 1 to 29, which were submitted prior to the noon deadline on February 4, 2025. They're as follows. Applicant's Exhibit 1, a summary of the history and timeline process for the Loveland property, pages 2, 3, 4 of the additional backup. It's noted that the staff provided timely review of the applicant's submittal plans and accepted the application once the application fee was paid on September 9, 2024. Applicant's Exhibit 2, the link of the Equity Now website. Applicant's Exhibit 3, the request for revision to one condition, page 8 of the additional backup. The applicant proposed a revision to staff's recommended condition 9. Staff has reviewed the proposed revision and is not in agreement with the revision. Condition 9 is related to the mitigation requirements for the removal of 7 specimen trees on site and will be evaluated with the subsequent Type 2 tree conservation plan. As stated earlier in the staff's presentation, staff supports approval of the variance to remove the 7 specimen trees. The proposed revision, in the staff's opinion, is not necessary since the condition already allows the on-site tree replacement, if proposed, to be placed in the woodland conservation easement. In addition, 2 letters from citizens were received in support of the applicant's requested variance to Section 25-121C3 for not providing the woodland conservation threshold requirements on site. An additional letter from Mr. Brooks, Vice Chair of the Prince George's County Council, District 8, has been received, referencing the Maryland House Bill 257 and supporting the project, and is included in pages 22 to 26 of the additional backup. This House bill, which is not yet approved, proposes to establish a food forest and foraging program on areas owned or managed by the Maryland Department of Natural Resources. The proposed lots are, to staff knowledge, proposed to be privately owned. Vice Chair Brooks also indicated in his letter that the woodland conservation requirements have been increased from 20% to 25%. Staff note that the woodland conservation percentage requirements have not been changed in 2024 Woodland Conservation Ordinance and remain at 25% as before. Staff also note that the Woodland Conservation Ordinance doesn't apply to orchards and they not count as woodlands. In conclusion, the subdivision staff recommends that the planning board adopt the findings and approve the preliminary plan of subdivision 4-23015 Type 1 Tree Conservation Plan TCP 1-028-2024, as well as the variance request from Section 25-122B1G, and disapprove the variance to Section 25-121C3, subject to the findings and conditions in the staff report. This concludes the staff's presentation.
Thank you, Ms. Van Dust. Commissioners, questions for the applicant at this point?
For staff, Mr. Chairman, because this really comes down to about almost 3/4 acres of coverage, right? But I know that Ms. Van der Duss, you went through it, but it just wasn't clear to me. Why can't the 0.71 acres be made up on site? I guess I'm referencing the applicant's proposed revision to condition number 9. Is there a reason why that cannot be made up on site or on lots?
Condition number 9 is regarding providing for the specimen trees on site.
No. I'm talking about the applicant's proposed revision to or addition to condition number 9. If I understand it, he's proposing that the 0.71 acre variance in terms of the woodland conservation is to be can be made up on site and or on the various lots.
Yes,
and I understand.
Yes, the applicant proposed those areas to be provided on the lots less than 1 acre in size. Specifically on the TCP1, it showed that the applicant proposed those areas on lots 6, 7, and 8, which are shown in light green on that slide, but it's not supported per Section 25-122B1L because the proposing woodland conservation on lots less than 1 acre would require a protective easement that would restrict the use of the lots for the homeowners. The minimum requirement is 1 acre to ensure that the building envelopes and yard areas are sufficient on private lots.
Okay, and maybe I'll hear more about it, but that I just wanted to be real clear about why that couldn't be done.
I
So,
can refer you to our environmental planning staff to uh, discuss this further.
okay, we don't have to do it now. I'll defer to you, Mr.
But
Chairman.
actually, Commissioner Washington, because I'm a bit lost on this too, so it might be helpful to just, even with the staff, to dive in a little bit more around where staff's opposition to this is. It would help me to be clear around this.
Yeah, because I'm about as clear as mud right now. So,
Yeah. So, and again, the only
Chair Shapiro, this is David Warner, Principal Counsel. Maybe I could just enlighten a little bit before Mr. Burke speaks.
Yeah, I would say one or both. And the issue is specifically around the woodland conservation threshold. I mean, because that's the variance that staff disapproves. And that's, I think, where Commissioner Washington and I are both looking for some more information.
Exactly. So Mr. Burke can speak to why this application does not comply with the law. But I wanted to make sure that the planning board was aware that this is a variance request, and the reason staff is recommending denial is that there are no special conditions in this project that created the unwarranted hardship, which is that this law requires woodland conservation to be entirely on site. So that's the legal analysis the planning board needs to make. But Mr. Burke can speak to why this application fails to comply with the law.
All right, thank you, sir.
Mm-hmm.
I've got a further question, Mr. Chair. So, Mr. Warner, are you saying that the condition is created as a result of the development?
So, simply put, the proposal that the applicant has presented to the planning board doesn't comply with the woodland conservation ordinance.
Right.
And so they need a variance in order to allow this project to go forward, even though it doesn't conform with the law. And the very first finding they need to show is that there are some special conditions associated with this property that are causing them to have an unwarranted hardship. And their unwarranted hardship claim is that they can't, build the number of lots that they want because this law prevents it because of how much woodland conservation needs to be provided. But the staff found that there's nothing special, there are no special conditions that would justify not imposing this law as it's written. So that's the finding. Yeah.
Right, but I guess and maybe this is what Mr. Burke is going to address, is why can't the difference be made up in other locations?
Yeah. Mr. Burke can explain why that is.
Okay.
Yeah, and I just want to ask a quick question just on design kind of stuff. So say we didn't have a cul-de-sac and they went up to Lumar Drive, or they redid this the design a little bit differently. If lots 7 and 8 were combined, and maybe parts of lots 6 and 5 are combined, so like the road went up or however it was designed, so they were big enough, would that get them to the amount that they need? Because I think they would still fall short from what my reading is, that they still wouldn't be at the 2.44 acres. But if they were to combine a few of the lots and they could count it per like the ordinance, would that be enough?
That may be a question for the developer, for the applicant.
No, I don't want the. I'm not interested in why they designed the lots small, so they wouldn't count. I'm interested in just like the green areas that we're seeing on here. If those were big enough so they could count it, however it is, like I don't really care how it's split up or how it's gridded up or whatever. At the moment, I'm just thinking like, is the green areas that we're showing here, would that even get them to the 2.44? Because my understanding, at least when I've looked through here in a couple different ways, which it's written in different forms, I don't think it still would. I think it would still fall short of like by almost a quarter acre or so. But I just wanted to find out, even if they gridded it up differently and they were able to have everything be like 1 acre sizes or whatever the requirements you want to do for them to count it, do they even still have enough on site?
So,
Mr. Burke can definitely answer that question.
yeah, excuse me. So if I may speak here, thank you. So good morning, Chair Shapiro, members of the Planning Board. For the record, my name is Tom Burke. I am the supervisor of the Environmental Planning Section. I apologize for my voice. It's, I think, just winter clutter here. But I think Ms. Vatendust did a great job explaining the regulations behind our determination. You know, the article, I'm sorry, section 122B1L of subtitle 25 restricts woodlands retained on lots less than 1 acre. So I guess before 2010, the code allowed lots to have conservation on lots less than 1 acre, and what we found was that they were ineffective. These lots were already a small size and left very little open space or recreational potential space for the residents of those lots. And since then, we've probably processed hundreds of single lot revisions to remove conservation on these smaller lots. So in 2010, the code was revised to allow to restrict conservation to lots 1 acre or greater when placed on the lots. So Commissioner Doerner, you have it correct that if lots 7 and 8 were combined, or if through design they were over 1 acre apiece, this wouldn't be an issue, and we could provide that light green shaded area over lots 7 and 8 and somewhat on lot 6 could count towards meeting the requirement. And I do believe, based on the numbers, that would satisfy the requirement to meet the woodland conservation threshold of 25% on site entirely.
So, do you know, Mr. Burke, do you know the acreage then? When I was reading through the staff reports and some of the applicant exhibits and stuff, my reading was that it was slightly different, that the on-site amount was going to be like, I think it was like 2.18 or something instead of like 2.44. So it didn't even still meet that 25% threshold, but I could have been reading the wrong stuff. And I just want to make sure that just if we were to erase all the lines, would they have enough green area on there?
Yeah, I believe they would. I thought we had done that math and figured that they would meet that requirement on site. And staff is checking on that now just to verify. But I believe that the way the site was designed was to meet this conservation threshold on site. However, these lots are substandard, and we couldn't count those areas on lots 6, 7, and 8.
Okay, that's helpful. Thank you.
I can add anything that the information that you are looking for is on staff report page 19 and 20.
Mm-hmm.
And Ms. Vatendust, to Commissioner Doerner's question, are you saying on those pages it says that it would meet the threshold?
Yes.
Okay.
Because I'm looking for a number, because that's going to be important. We have a minimum number of 2.44. When I've read the staff report before, it looks like it actually falls below because they're not counting lots 7 and 8. But I want to know, like, if we just erase all the boundaries, like what would they have for on-site? Because I'm still not seeing that number, even on page 19. I'm seeing that it would be 1.73, which is still too little. It's not enough on there. So do we have a number that would be in excess of that 2.44? Or at least
yeah. I'm sorry. I believe that we do. I believe that it does make those numbers do work, and I do apologize. Staff is doing that calculation now. I know that we figured that in our evaluation.
But Mr. Burke, just have staff do the work, and Commissioner Doerner, as we move along, they can get that information and jump back in with us and make sure we get the answer to that question, because it's certainly is a threshold question for me too.
Yeah. So that'd be great. I
Right.
just got confirmation so that area, the areas provided on lot 6, 7, and 8 do add up to the 0.71, which is the deficiency. So for what we would allow based on the lot sizes, the 1.73 acres of woodland being provided, added to the 0.71 acres that we cannot consider because they're on substandard lots, add up to the 2.44, which meets the woodland conservation threshold.
Substandard as in under 1 acre?
Substandard as in under 1 acre, that's correct, per
Okay.
122 B1 L.
Okay, thank you.
So I'm sorry. So, Mr. Burr, what you're saying is lots 6, 7, and 8 would need to become one lot in order for that the light green to be able to be counted. I just want to make sure.
I mean, not necessarily, and we're not certainly, we don't want to, we're to design this for the applicant so much.
No, I'm not. I'm just trying to be clear about what we're saying.
So the preservation areas shown, that those light green hatched areas shown on lots 6, 7, and 8 would have to be on a property that was 1 acre or greater.
Right.
Got it.
So if these lots were reconfigured in such a way that, I don't know, maybe lot 6 came across the backs of lot 7 and 8 in some fashion that, and I don't know, I don't want to play into, minimum lot sizes and all that.
You've answered my question. Thank you.
Wonderful. Yep.
Yeah, that's clear. It's helpful.
Thank you.
Sure.
All right, other questions for staff at this point? I'm sure we'll be coming back to this after we hear from the applicant and folks in the community as well. If not, let us turn to the applicant. I'm sorry, was there something? No. Turn to the applicant. Mr. Rivera, we'll start with you. And if you want to introduce members of the team, if you want anyone to speak, I'll swear them in at the appropriate time. But the floor is yours.
Thank you, Mr. Chairman, members of the board. Good morning, everyone. My name is Norman Rivera. I'm representing Loveland Development, LLC. Some of the members are here. I will introduce you as part of our team. Right there in the middle, Miss Natasha James, and her husband is here, Shamari James, and one of the other family members, Amina Williams, is also on the line. They are the owners. They are a family. They have bought this piece of property to create a legacy family compound. So that is the basic tenet of this proposal. So they're not builders, developers trying to max out density. They seek to establish a long-term commitment to the county. And I don't want to steal their thunder, but they have a group called Equity Now, which is a platform for just that, for education, for business opportunities, to create legacy wealth. They also are the owners and operators of Legends Charter School on Philadelphia Court in Lanham. That school went through the mandatory referral process some time ago, and they're up and operating, very successful, helping educate the children of this county. As a charter school, they're also become part of the Prince George's County public school system. So they're vested not only in the fabric of the community in terms of education, but they also want to move their family to these 8 lots on this totally wooded parcel, and they will speak to those issues later much more eloquently than I. So I would address the more mundane technical issues, but to clarify some of the confusion the board had about the woodland conservation. You see the property is all wooded right there. And if you could turn to the slide that showed the lots and the specimen trees. There you go. So I think the confusion, Ms. Washington, Mr. Dorner, and others, is that the site is wooded. 2.44 acres threshold conservation requirement is actually already on the site because it's totally wooded. We're only clearing the minimum necessary to put the houses, which are those little square boxes there. The issue is lots 6, 7, and 8 happen to be less than 1 acre. So they're only substandard in the fact that they're less than 1 acre. And the code requires or suggests that you can only have on-site, on-lot tree preservation if it's 1 acre or more. What the staff has said in the report and today is that they get numerous requests from homeowners to remove said tree conservation easements. Well, the fact of the matter is that's sort of a what if situation. These folks are not going to do that. They want to preserve the trees. In fact, you will hear from them very ardently that they want to have a food forest, which coincides directly with House Bill 257 and Senate Bill 317 that encourage food foraging on DNR lands so that folks with a permit can go out and get fresh vegetables or whatever they can find. Maybe they'll find, what are those mushrooms? Gosh, I forgot, truffles. And they can eat those. So, we want to do the same thing here. They want to not only keep the forest that's there, they want to add to the forest by creating a food forest environment so there's sustainability. And before I get into the variance stuff, the technical issues, there's a lot of planning dialogue, and I'll just read a few tidbits from the staff report, not to bore you, but the planning underpinnings of the master plan, Plan 2035, the Green Infrastructure Plan, et cetera, all talk about preserving and enhancing environmental features. Page 23 of the master plan for Henson Creek South, I'll just read it. It's page 2 of the 9/19/24 community planning memo. Implement new patterns of development that preserve and enhance the environmental features and green infrastructure elements. A strategy is preserve the existing environmental infrastructure resources, including forests, open space, and sensitive habitats. Encourage sustainable design as part of the development review process. The reason that the staff is recommending denial is that not because the trees will be removed. We're not asking for trees to be removed on 6, 7, and 8. We're asking that they actually just be counted, because trees are trees. Just because it's on a lot less than 1 acre doesn't mean they're not trees. So that's my sort of pragmatic approach to this. The other lots happen to be more than 1 acre, but for that arbitrary distinction of being 1 acre or less, the green areas in the light there on 6, 7, and 8 would be counted. The staff notes that the lots 6, 7, and 8 may be too small, but you can see that the house sidings are right there. There's plenty of room for the house. We have to design it, the house with the front yard setback. There are various design parameters for the cul-de-sac. Obviously, you can see from the drawing there, the design fits the houses, and we wouldn't design a subdivision for 8 lots that wouldn't fit the houses. So it's just incumbent upon the applicant as a family versus a typical applicant you might see to maintain that value. And I don't want to go into more of their thunder, but that's sort of the background of why we're here. When you look at the staff report on pages 6, 7, and 8, we talked about, where is that? Ensure that the design of new development in suburban residential areas maintains or enhances the character of the existing community, which we certainly think this will. And at the bottom of page 6, under strategies, this is a really good one. Develop comprehensive, well-designed neighbors and communities, not just individual housing units, to enhance their value to the owners and to the county. So they think that the food forest concept, that the family compound will certainly have a strengthening of the community fabric of this area and meet that goal. Likewise, on page 7, it repeats that same finding about enhancing the value to the owners in the county. So there's just simply going to be more trees and fruit forest trees and other trees that can be used for farming. Page 10, I'm sorry. The bottom of page 10, the planning board may impose conditions on the development approval to achieve a legitimate public purpose. However, the planning board cannot withhold or condition the development for reasons unrelated to the public purpose. In my opinion, to deny the variance would be opposite to the public purpose, because we couldn't count trees that actually are already there because it's not on a lot of 1 acre or more. Trees are trees again, and I think it would be more fair for the county or the planning board and commission to recognize that effort to save these trees. Page 14 and 15 of the report, ensure that areas of connectivity and ecological functions are maintained, restored, and established. So by maintaining all these trees at the back of lot 4, 5, 3, and all the trees that are on site in 6, 7, and 8, we are exactly doing that by enhancing the green infrastructure network. It should be counted because whether or not you count it or not, it's still part of the environmental network. And we should recognize that. 1.1D strategy, recognize the ecosystem services provided by diverse land uses such as woodlands, wetlands, meadows, urban forests, which is what we want to do. So when you go through the report, it's replete with issues measuring and identifying ways to try to improve the environmental habitat, and that's what we want to do. Turning to the actual variance itself, it's on page 19 of the report. Just to re-clarify it, we're short 0.71 acres of the 2.44 because it's simply not on a lot that's 1 acre or more. It's not that the trees aren't there, the trees are there. It's just we would like the ability to put a conservation easement over those backs of those 3 lots to preserve them. And obviously a conservation easement, they would even sign a covenant to protect them. For example, the regulated environmental features that are mentioned on page 25 are also supposed to be placed in conservation easements. So we're not sure why a conservation easement for an REF is different than a conservation easement for on-site trees. An easement is an easement, and you will hear from them shortly about how they want to make this effort a leading planning example in the county. If more and more people do this, it'd be better. The state has done it with food foraging, and that bill should pass. I know Councilman Harrison a while ago passed a bill with the county council to allow urban farming on lots. So this is part of a trend, and we all know that food insecurity is a huge issue as things get more and more costly. And we want to be more, in hindsight, more conservative in terms of our land. I know, Mr. Giraldo, you and I had discussions. I think Ms. Bailey was involved in my 2 solar farm projects, and you were concerned that the prime farmland underneath the solar array was not being utilized properly. It would be a waste of good farmland, good soil, just because solar stuff was on top of it. Here we're combining the concepts of food forest, environmental sustainability, food insecurity, combined with a family compound. And all we want to do is say 0.71 acres on the backs of 6, 7, and 8 can be allowed to be used as a woodland conservation easement. I'll stop there, and then I'd like Ms. James and the other 2 speakers to address the board. They are much more influential than I am, and so I will defer to them. Ms. James, I think you have to be sworn in.
Yeah, that's correct. So who's going to be speaking? We have Ms. James, Mr. James, and Ms. Williams. Is that correct?
Yes.
I ask all of you to raise your right hands, please. Do you solemnly swear or affirm that your testimony will be the whole truth and nothing but the truth?
I do.
I do.
Okay. Consider your all self under oath, and I will leave it to you all to figure out who's going in what order.
Well, good morning, everyone. My name is Atasha James, and I'm actually a former middle school science teacher. I taught earth, life, and physical science. And so the project that we propose is absolutely in line with our family values. I like to set the table for you and let you guys in on the history of our Love Land project. Our Love Land project is a dream for our family, who is a very large Afro-Puerto Rican family, and we really love each other exceptionally. And we wanted to create a forever land where we could grow old together and leave a legacy behind for our grandkids and their grandkids. And so developed in the covenants of our land is that it will remain in our land and be unable to be sold and to be willed down to future generations. And so thinking about our commitment to our sustainability and making sure that my grandkids could be able to walk through their land and pick berries off of trees so that they could understand how to keep themselves alive and sustainable in the event that the supermarkets are closed. And so I'm going to read the prepared testimony that I wrote. So I appreciate you for opening up your heart and mind to what I have to say this morning. I stand before you today as a daughter, a mother, a business owner, and a proud member of a family that has long invested in the growth, prosperity, and future of Prince George's County. We are here today to advocate for Loveland, the name of our land, the name of our property, and the name of our development, not just as a development project, but as a vision for what is possible. When families are given the opportunity to exercise self-determination, innovation, and sustainability in the place they call home. For our family, Loveland is more than land. It's legacy. It's the promise that generations of our family can live, work, and thrive together, building upon the foundation of those who came before us. It's the opportunity to create a model of sustainability that not only serves us, but as a beacon for what intentional, responsible development can look like in Prince George's County. We have already lost from our 10 acres, one plot of land in this process, and we have made tremendous sacrifices to get our family in a position to undertake this project. And we're asking for you guys to consider, as our attorney said, that our trees, and the easements are there. And our goal is not to diminish what is already there, but to enhance the land so that we can live and grow and eat off of that land, quite literally. What Loveland means to us is living in unity and valuing each other. And there's nothing more precious to us than saving every possible tree and utilizing every particular resource on that land to allow for us to continue to meet our goals of self-determination. At its core, Loveland is about love, the foundation that strengthens our bond and fuels our collective vision. It's a place of elevation where we will be able to lift each other up for growth and abundance. For me, particularly as a public servant, I'm hyper aware of the food deserts and food insecurity that are real growing threats in our country. Loveland presents an opportunity to combat these issues directly by establishing a food forest. Our urban agriculture is a sustainable and regenerative source of nourishment that benefits both our family and the larger community. We're not asking for anything beyond the opportunity to move forward with an enhanced, innovative solution, one that aligns with HB 257, one that, if granted, will exceed the Woodland Conservation Ordinance requirement, and one that proves responsible development and self-determination can go hand in hand. This is not just a decision about zoning or conservation. It's a decision, in my opinion, about fairness, self-sufficiency, and the future of community-led development in Prince George's County. Families like ours should be encouraged to move forward and develop on land that they intend to inhabit for futures to come. We urge you to look beyond the standard processes and recognize Loveland for what it truly is, an opportunity. It's an opportunity to model sustainable living, to demonstrate again that self-determination and responsible development are not only possible, but necessary, and to make Prince George's County a leader in innovative, community-driven solutions. Loveland is not just for today. It is for generations to come, and we're asking for your support to make sure that all 8 members of our family who have invested in this property can realize the dream of being homeowners and adding to our family's larger legacy. Thank you for hearing what I had to say.
Thank you, Ms. James. Appreciate that. Are we going next to Mr. James?
Yes. I'm also going to read the testimony that I prepared for you all. Good morning, everyone, and thank you for hearing me out. My name is Shamari James, and I'm here today to speak not just for myself, but for my family, generations past, present, and future, who have invested in Loveland as our forever home. We have approached this development with careful planning and deep respect for the land, ensuring that sustainability and responsible stewardship guide every decision. Yet, despite our commitment to conservation, we are being forced to bear an undue burden that threatens the integrity of our vision. One of the most significant unfair conditions imposed on us is the increase in the conservation requirements from 20% to 25%, which results in the outright loss of a lot. That's an entire home that would have housed a family member and contributed to our self-sustaining model. We question whether these same conditions are applied consistently across all developments in the county, particularly when large developers submit their plans. However, we are not asking for any special treatment. We are simply asking for the opportunity to move forward with an enhanced, innovative solution that aligns with HB 257, which the state has introduced to support creative and sustainable approaches to land use. Moreover, our approach to conservation exceeds the county's woodland conservation ordinance requirements rather than merely meeting the minimum standards. We are designing a model that integrates food production, renewable energy, and environmental sustainability to ensure that our family's presence on this land enriches the ecosystem and the community. This is not just about zoning. It is about self-determination, our ability to build a community that will remain in our family forever, using forward-thinking strategies that will align with the county and state sustainable goals. We urge the board to reconsider these restrictive conditions and allow us to demonstrate that sustainable, self-determined communities are not just possible, they are necessary for the future of this county. Let us move forward with a solution that works for conservation and the people who have invested their lives. Thank you, guys.
Mr. James, sorry about my dog.
You're okay. I have 3 cats myself, so I'm used to that.
Thank you, sir. Ms. Williams, you gotta go?
Good morning. Can you hear me?
Yes, ma'am.
Good morning, members of the Prince George's County Board. My name is Amina Williams, and I'm honored to speak before you today. I am an entrepreneur, a school founder, parent, veteran, and a proud citizen of gorgeous Prince George's County. I'm here today to request a variance to the county's conservation policy so that we may implement a food forest, a sustainable regenerative conservation model that exceeds environmental standards while providing long-term benefits to both the community and the land itself. Our plan not only meets conservation requirements, but enhances them in ways that aligns with Maryland's forward-thinking policies. However, this variance will be forced to eliminate without this variance, we will be forced to eliminate one of our planned homes, displacing a family member who has built their foundation around this vision. This is an outcome that would deeply be disappointing and detrimental to the integrity of our community's purpose. Prince George's County is my Wakanda, a place where families, culture, and the environment coexist in harmony. This land represents more than just a development. It is a legacy that I intend to leave for my children. Loveland is an example of what's possible when sustainment, conservation, and family growth come together to build something lasting. I'm here because I want to continue to invest my time, my money, and my energy in preserving that vision for my generations to come. Loveland is more than just a development project. It is a legacy of stewardship. We see our land as not just something to exploit, but as something to nurture and sustain. Our proposal does not reduce the amount of conservation land, but instead applies an adaptive conservation model that is forward-thinking and sustainable. Imagine walking through the Loveland Food Forest early in the morning. The canopy of black walnut and hickory trees stretch high above, filtering golden sunlight through their leaves, creating a peaceful, dappled effect on the ground. As you move through this space, persimmons and pawpaws sway gently in the breeze and their scents carried on the air, inviting birds, butterflies, and bees to dance between the branches. The lower layers are alive with blueberry and elderberry shrubs, their deep indigo and vibrant red fruits glistening with the morning dew, waiting to be harvested by families who call this place home. Beneath your feet, a lush carpet of thyme, oregano, and sorrel spreads across the ground, not just preventing erosion, but also filling the air with earthy, aromatic fragrances that soothe the soul. This is not just land. This is our land, and we are committed to keeping it healthy, diverse, and abundant for our children and their children. Maryland House Bill 257 acknowledges food forests as legitimate conservation model. The Maryland National Department of Natural Resources recognizes agroforestry as an effective approach to land conservation. Loveland can serve as a model pilot program for Prince George's County, demonstrating an innovative way to meet conservation standards without unnecessary displacement. Losing a lot would mean displacing a family member who has planned to live in this community. We have proactively incorporated conservation commitments into our bylaws and covenants to ensure the land remains protected in perpetuity. The Planning Board has an opportunity to support a sustainable, community-driven conservation solution without penalizing responsible landowners. A food forest meets and exceeds traditional conservation benefits by preserving natural tree canopy and increasing biodiversity, supporting soil restoration, water retention, and carbon sequestration, and aligning with state policies that recognize agroforestry as a conservation tool. We have committed to establishing a perpetual conservation easement that legally protects the food forest, including conservation requirements in our community bylaws and covenants, and implementing community stewardship plan that to maintain the land and ensure compliance. Standard conservation areas are often passive with minimum community and environmental benefits. Our approach protects more tree canopy while enhancing soil and stormwater management, creates an active conservation space that provides ecological, educational, and food security benefits, and reduces long-term maintenance costs for the county while enhancing climate resilience. This request is not to bypass conservation laws, but to enhance them through alternative compliance model. This is more than just a variance request. This is the chance for Prince George's County to reaffirm its commitment to progressive conservation and community-driven sustainability. We stand ready to be stewards of the land, to nurture it, and to share its abundance with future generations. We urge the Planning Board to approve the Loveland variance request and allow our food forests to serve as community-focused, environmentally sound conservation strategies. Thank you for your time and consideration.
Thank you, Ms. Williams. Commissioners, are there questions for the applicant at this point?
I don't have a question. I just want, I love what you all are working to accomplish. Let me just say that. And I would really like for us to try to figure out how we can do this. I am a third generation family member with Air Property. So I am living what you are describing. And I just love it. I probably shouldn't say that because I do have to vote on this. But I really would like for us to see how we make this happen. One question, Mr. Rivera mentioned a conservation easement. Mr. Rivera also used words like suggest and may as it relates to woodland preservation. I'd like to know what the law says. Is it a requirement? Is it a suggestion? Is it I don't know. I'm just reacting, quite frankly, Mr. Chairman. Hopefully we can figure this out.
If I could, Commissioner Washington, it won't be a may or suggest, it'll be a shall, which is the highest enforcement word you can use in a resolution. So as the conditions state that the regulated environmental features shall be placed in a conservation easement, we will also, I proffered a condition that I think the staff misconstrued or construed as part of the on-site mitigation for specimen tree removal, but it would be a separate condition just to make it clear that woodland conservation can be permitted on lots, shall be permitted on lots with an easement 6, 7, and 8, which covers the 0.71 acre shortage we have. Therefore, will meet the overall 2.44 acre threshold requirement totally on site. It's just that on those 3 lots that are less than an acre, it shall be placed in the conservation easement to protect the trees, and that will make sure that it is enhanced, insured, and protected.
Thank you.
You're welcome.
I have one question. So if the staff mentioned combining 6, 7, and 8, so you would lose 1 lot and you can still have your food foraging, is that right?
Yes, but we would lose 1 lot, and that's the hardship that would occur by not granting the variance. On page 20 of your report, there's 5 or 6 criteria about how a variance can be granted. There's a special condition here with the sort of irregular shape of the property. It's totally wooded. The woodland conservation process did allow preservation on lots in the prior code. Now we're stuck with the new code. But for that one time and change in the law in July of 2024, we would have been able to do this anyway, as I understand the law. So the undue hardship would be the loss of the lot, which is critical. In their exhibit that Ms. James submitted, they've actually put the names of the folks on the family on each of these lots. So they're pre-sold, if you will, and it would be disastrous for them because they have allocated their budgets and everything so that this project can continue. So while it's theoretically possible or technically possible to do that, Mr. Giraldo, it's just not feasible and would destroy the integrity of the concept. The other conditions of a variance approval are the enforcement of the rules will deprive the applicant of rights commonly enjoyed by others in similar areas. So denying this variance would deprive the applicant of the use of a lot just because it's less than 1 acre, which is to me very arbitrary. C, granting
code. That's the code, Mr. Rivera. It's
Yes.
not arbitrary.
Not
It's the code.
arbitrary. Hmm.
Yeah.
It's not arbitrary. It's the code. That's what the law says.
True, but the law also provides for a variance procedure. They're saying you should have a goal of 1 acre or more to preserve, but the code also allows for a variance procedure. We just feel like we meet those requirements, and that's how
Here's
we.
my concern. My concern is what you just said before about it would deprive them of rights given to others. So if a variance is given now, then who's going to stop other situations similar to this saying, well, you gave a variance to so and so, and then it kind of defeats the purpose of the code, and it defeats the purpose of why that was legislated initially. That's my concern.
Mr. Giraldo, can I add to that? Because that's actually what I was seeking clarity from. And maybe Mr. Warner, does the code say must be 1 acre or more, or how, what is that language? That's what I'm trying to understand. Because the law is the law, to your point, Mr. Giraldo, Commissioner. What does the code say? Does it say it must be 1 acre or more, or should be 1 acre or more?
What David Warner, Principal Counsel. So what the County Council adopted in 2024 was a requirement that all woodland conservation be provided on site. So all 2.44 acres need to be on site. And what has always been the case since 2010 is that you cannot provide for your woodland conservation on lots that are less than 1 acre. That's been in the law since then.
Okay, so it's not ambiguous.
It's not ambiguous, and it's incorrect to refer to it as a, I think the terms used were arbitrary, or the code suggests that. I mean, it's the law.
Okay, but that's what I was trying to understand.
Yeah.
Okay.
So a variance is allowed, but I think the focus of the board needs to be on page 20 of this staff report, because so far the testimony hasn't addressed what you need to do, which is evaluate whether the special conditions the applicant is claiming is causing them a hardship not to be able to build all their lots. And staff analyzed each one of the special conditions the applicant put forward and found that none of them were met the requirements of the law. So what you really need to focus on is page 20, the applicant's second paragraph under A. Applicants proposed special conditions. Staff analyzed each one of those, found that they were not peculiar to the property, and therefore couldn't have caused the unwarranted hardship. And then the second analysis is, even if you find the special conditions are causing them to have a hardship, applicant has to show there's no other way for them to use the property the way they want to use it. In other words, reconfigure the lots. They could have, a different way of accomplishing their objective. So that's where the planning board needs to focus their attention.
So, I'll just chime in and let me just politely correct something you just said, Mr. Warner, that it's not the way that the applicant wants to use it that is the criteria, because they could say they want to have 16 lots. And if that's not possible, that's just not possible. It doesn't matter if that's what they want to use it. And,
right.
and I say this respectfully to the Loveland idea and stuff. I think the idea is fantastic. It's super cool. And I also have potentially down the road, my side of the family has several lots that are all actually connected on my wife's side. And the idea is that we're going to maybe live in that as well, because we have grandmother, mother, we have a business and everything. Well, not we, because I don't own it, but my wife's family all has that stuff together. And I think the idea of living together is really cool. So I'm certainly, I like the idea itself, but this is, in my view, this isn't a hardship. I know that you have 8 people who want to live here. You have 8 lots right there. If you lose one from like a legal perspective, so disassociating myself with the emotional idea or the kind of what's happening right now, losing one lot is not a hardship. If you lose 4 or 5 lots, then maybe, but losing one lot is not a hardship. I haven't heard anything about redesigning the lots. And I mentioned something before about like, well, could this be redesigned or some other way? Like, I haven't heard that like there's anything particularly different about this lot that would make it impossible to redesign. And in fact, if these lots were combined, you could have 7 lots. So just losing one, if we had an applicant that came up and said, I want to sell 8 lots, how do we differentiate between that versus somebody who has a family that wants to be together? Like the law doesn't create that there's abilities for us to choose about the use or the way that the applicant wants to differentiate with it. We have to treat everything equally as long as it falls within the zoning. And what I'm seeing here, we're not meeting the criteria for the variance at all within here. But I like the idea that Mr. Rivera proposed about potentially having the woodland easement, and maybe that's a way of getting around it. I don't know if that is. I think, in my view, and I'll just be frank right now, from what I've heard, I'm going to vote no on the variance because I don't think you've met the criteria legally at all. However, I would be in favor of the rest of the case, and it might be worthwhile to think about exploring that with staff, and because I haven't heard anything about this woodland easement, if that would actually be possible to make this go through, and then potentially not have to worry about getting the variance. And then the rest of the case is in hold. And then in my view, like I don't have any problem with any other part of the case. It's just that variance right now that like I wouldn't vote in favor of. And you would still be able to develop it. You just wouldn't be able to develop it potentially in the way that you want to do. Versus if you were to take a little bit of time off and think about like working with staff or take a break, then you might get there. But right now, if we have to vote on what's added today, like I'm just not seeing that. Like I just don't agree that that's a hardship in any way because you can still use your lot. It's just not how you want to do it, but that's because you drew it up in a certain way. If you hadn't drawn it up that way, like maybe there's a different way of doing it. I don't know because I haven't gone to the pen and paper and I haven't seen anything suggesting that this is the one and only way to develop the lot. Because it's more or less a rectangle within there. It's a little bit of a difference within there, but doesn't look physically that different from other stuff that we've seen before that we've allowed variances because of like shape or physical structures or anything like that. So I don't know. I like the concept. I'm not a legislator. That's not my role. I can't change the law, and I can't change it based on like a case by case basis and decide that I'm going to nullify it and not go along with it for this one case because I like the concept. That just wouldn't be a consistent application, and we'd wind up in court every other way if we did that. And we wouldn't preserve the integrity of what we're trying to do if we did that, unfortunately. So from like a legal perspective, I don't think we can get there how it is today. I think there may be other ways for you to get this and to actually save what you're trying to do and get it done. I just don't know. And I think that would require more extensive chats probably with staff and other people. And I'll leave it. My question then would be to Mr. Rivera, like, is there a way to get there? And because you're usually pretty creative on things and can you get there and do you need more time or what are you kind of thinking on that?
Thank you, Commissioner. I guess I really will miss you when you leave. Just kidding. Kim Morgan, our engineer, is on the line, and she can address the redesign issues. But before she speaks as to that and some creative solutions, these are all case-by-case issues. But I don't think you're setting a precedent because each case has to stand up on its own. So I appreciate your opinion on that, and I'll address that on my summation. But Kim, can you raise your right hand and get sworn in, and she can hopefully address some of the design issues, Commissioner.
Mr. Rivera, just to make sure, Ms. Morgan, I don't see Ms. Morgan signed up on our list anywhere.
She had that confirmed by Ms. Jones earlier today because it was missing, and then they found out she was.
Excuse me, Commissioner, I'm sorry, Chair Shapiro, yes, we did. We were able to locate her registration and we sent her the link.
Okay, thank you. Thanks for clarifying that. Ms. Morgan, if you could raise your right hand. Do you solemnly swear or affirm that your testimony will be the whole truth and nothing but the truth? And consider yourself under oath, and you're on mute. You got to turn your mic on.
Sorry. Good morning, Commissioner and members of the board. I did submit a 3-page letter for the record that It's my short summary of what my clients and Norman's clients have gone through since the beginning of this project. Again, my name for the record is Kimberly Morgan, and I'm the president of the Land Tech Corporation. We've been working in Prince George's County, myself for 30 years. Our firm's been in the Prince George's County for 40 years. As you know, the governor of Maryland is speaking affordable housing. We all understand that's not going to occur until there's less regulations. And unfortunately, with CB20 and CB22, we now have more regulations, which the clients have been burdened with on this particular property. To speak to the engineering, here's a short summary. The very first plan that we have to prepare for a project is the natural resource inventory map. We prepared that map. We obtained a letter from Prince George's Department of Inspection and Permitting, Inspections, and Enforcement. And they gave us a letter basically saying that there was no floodplain on this property. We obtained approval of the NRI. We submitted the site development concept plan, and while that same agency reviewed the site development concept plan, they determined that, oh my goodness, there was floodplain on the site, which you could see in that one drawing that was up in the PMA. So not only did they ask this particular owner and applicant for us to do a floodplain study for a very short piece of this property, we also had to dive into the Tinkers Creek floodplain, which has a drainage area of over 2,000 acres. It was done many years ago. DPI was they weren't able to give us a lot of information, so my clients had to spend my time and their money for us to recreate that floodplain and then create the floodplain on the property. This required a revision to the NRI that was already approved. CB20 and CB22 now have expanded the stream buffer from 75 feet to 100 feet. And so we are now required to do a third revision to the NRI. All of this is time and money for the owners of this property. In addition to that, we submitted a grade establishment plan, which is the document, it's the construction plans that determine the horizontal and vertical elevation of the extension of Arden Lane. As you see where existing Arden Lane is, that is a fixed location. We had no other place to say, well, could we connect here or we could connect there? The answer was no. So as a result, when we submitted the grade establishment plan to Prince George's County DPI, they had to grant us variances of the design regulations for both horizontal requirement and vertical requirement of that roadway. So that presented another hardship for us creating the lots, because this being the RE zone, the RE zone requires the lots to be a minimum of 40,000 square feet. The front building line has to be 120 feet and 50 feet at the street line. The drawing shows that several of the lots are set back. In fact, homes on lots 3, 4, 5, and 8 must be set back a distance equal to 120 feet, which again causes a problem with the way we created these lots. This just wasn't a place where you could take a look and say, okay, here's how many acres we have. Let's divide it all up, put the road in, and everybody gets an acre. It didn't work that way. And so we finally got the grade establishment plan approved, and that took extra time and money for the owners of this property. Then we got the hydraulic hydraulic planning analysis done through WSSC. One of the drawings that was up, if you could change the drawing that shows the site, there is an existing sanitary sewer line that runs along the whole bottom part of this property. That line was built there you can see it runs along the back part of that dam. It runs along the back cuts through lot 1, right through the center. It's behind the lot 2, lot 3, lot 4, and connects into a sewer line that's in Pinkers Creek. That line was built in 1972. Part of the requirement for WSSC is that they want paid back for the construction of that line by the owners of this property to over $25,000. We are still trying to work with WSSC regarding that fee. So due to the fact that these lots have to be set back, and I do want to mention that when we met with with the applicant, the owners early on in the project, it appeared that they would like to build custom homes. And so we do show the building footprint that we show on all of these lots is about 20% larger than a typical building footprint for a single family detached home. It is a large building footprint. And they do have the 40-foot backyard usable area that has always been something that Prince George's County has wanted for extension of decks or swimming pools, etc. And then on top of, so we were constrained by a lot of information, the PMA, and then DPI wanted us to pick up the flow from existing Arden Lane, the storm drain, and pump it around the site to the floodplain. So all of this was taken into consideration when we laid these lots out. If we could have tweaked any of these lots to make 8 and 7 bigger than 1 acre, we would have moved everything around, but we were constrained with the front building lot lines that are required, with the area and the vertical and horizontal elevation of Arden Lane, and then the extension of all the utilities. I can answer any questions if you. I gave a much longer story that's in the record.
That's much appreciated, Ms. Morgan. Thank you for that. Commissioners, questions for Ms. Morgan?
Yeah, quick question. What's the size? I can't see it because it's on another slide and zooming in. What's the size of lot 6 within there? Because I'm just wondering from like site design, it looks like you could shave off potentially some of lot 3, give it to lot 4, transfer some of lot 5 to lot 6. Like there might be ways of you kind of getting around just slight redrawings of these things to get what you need. Because that cutout right there of like lot 8, I think you could probably take it around. You could get 0.7 acres if you're just careful about this stuff. It's going to look a little bit weird because you're not going to have straight lines, but I'm just eyeballing these things and wondering if that's even possible.
Yeah, I see what you're saying, Mr. Dorner.
In a normal construction, yes, that might be possible. And this would be something I could talk to our applicants about, our owners about. In a normal world, if these were fee simple lots to be sold to individuals, we would never do something like that, because you would get into a situation where you're going to have 2 people arguing over whether the rear of the lot is theirs or the people next door. So in standard land development layout, we would not do that if these were sold individually to people that weren't a family. We could look at that, but like I said, we would not do that. Now I'm trying to see, I think that lot 6 is about 43,000. I'm going to pull up my drawing.
Yeah, I can see it now. It's 0.95. It looks like if you had like a little foot that went into lot 4, you could draw off some. Lot 5 is 1.07, so you could donate 0.07 to lot 6 and basically get there right away. You just need to figure out how do you like shift it over in a Tetris kind of weird move. But if everyone's going to be living there, if it's a family and you're worried about the forest, like if people are going to have an easement or whatever it is, like you're just cutting the forest. You're not even going to develop that anyways.
Right.
Yeah, I agree with you, Commissioner Dorner. I mean, the novelty of this entire project is that it is one family. Yeah. So this is not like you're selling to independent homeowners. Maybe go back and work with, I think Commissioner Dorner, you mentioned earlier, work with our staff and come up with a proposal, shaving here and there to get what you need to accomplish your goal. And
we would need to pick up about to about 9,000 square feet, which we did at one point look at that, and it was questionable, but we can surely discuss it with the applicant and do something that's very non-traditional.
I think that's the only option, at least at this point, because, you know, regardless of how we feel about the project, and I'm sure I have emoted the most, what we cannot do is do anything that's contrary to law. I mean, that's just a fact.
Right.
Right now, what's being asked of us is to do that, and we just can't.
Yeah, Commissioner Washington, I kind of agree with you and Commissioner Dorner. Looking at it, I was studying the schematic or the drawing, and I think if they kind of each lot gives something to somebody else, that, and while it's not traditional, it may get to the point that the variance would not be needed.
Let me jump in on this just for a second. First of all, we're still in the middle of the public hearing. There may be other issues. We may have folks in the public who signed up to speak as well. So I just want to make sure we continue the public hearing process. Clearly, this is the sticking point, and we will get back to it. But let me continue on the process so then we can get back to this and make sure there's not other things as well. Okay. So
thank you, Mr. Chair.
Yeah, so hold off on the questions for now, and I'm going to turn to the public, and just to make sure that I'm not missing anybody from the public who is looking to speak. I do have a couple folks signed up, Ramey and Clifton Tolson. Either of those folks here?
Yes, Mr. Ramey is present.
Mr. Ramey, okay, you are not with the applicant's team, right?
No, sir.
Okay, all right. Mr. Ramey, I can't see you, but I can hear you. I don't need to see you. But if you are going to stay on audio, I need you to still raise your right hand so I can swear you in.
I'm happy to turn camera on here as well. I just didn't want to be a distraction.
No, no worries at all. Thank you, sir. Do you solemnly swear or affirm that your testimony about the whole truth and nothing but the truth?
I do.
Okay. All right, sir. Consider yourself under oath. You're speaking in opposition? Are you undecided? You're supporting, or?
I'm kind of in the middle. I think I speak from the same voice that I hear a lot of others. This sounds like a great idea. Wonderful family. Congratulations to them for putting themselves in a position to do this. But a lot of what I'm hearing is about the Loveland family, and we haven't really spoken about the community at all. I come from a place, I work in this industry. I've been in housing for over 12 years. I do data analytics and technology work in this space. So I'm very familiar with a lot of what happens here. I've been a part of board meetings like this. I'm lucky enough to currently be on parental leave, so I've been relieved of these meetings for a while, but a little bit of PTSD going on at the moment. Again, I think that this sounds wonderful. I think the intentions sound great. And quite frankly, the Loveland this sounds like a family that would be welcome in this community. I've been in this community now for about 10 years. It is filled with multi-generational families. We live next door to a son who lives next door to his mother. There's children and everything. This is a very welcoming community. We watch out for each other. We let each other know when people are going on vacation to watch the homes or the cars in the driveway. But it is a large community. There's hundreds of homes. We all use the local handyman for various projects. I mean, it is very communal here. And while the intentions sound great, intent does not guarantee execution. Intent does not guarantee future sustainability. We're talking about making exceptions here with no guarantees necessarily. I mean, I didn't see a lot of the subject matter that's been talked about was not presented in the proposal that was presented and that I reviewed. I might have had different views or questions based on that prior, but we're kind of finding out this in the moment, and that's a concern. What part of these verbal statements are actually going to be committed to on paper and guarantee the sustainability of this community. The verbiage is a little strange to me. When I hear compound, I don't think welcoming the community and birds and trees and sunshine. I hear gates and exclusivity. That's not a great terminology to be presented here that makes the rest of these families feel welcome. I don't believe, again, that was the intent, but when you read between the lines, there's a little bit of truth behind some of these words. The proposal, I believe, has a lot of potential. I think it's an amazing idea. I think it's something that this county really, truly needs. But at the same time, as was mentioned, the laws are in place for a reason, one way or another. I think this county has dealt with enough turmoil from codes and properties and HOA scenarios that these things were put in place to try to better this community and better this county. And I think it's important that those things are reviewed and upheld. I think that this current situation, again, I haven't heard anything that actually helps this community. It seems to be something where there's a trend, which has happened in the past here, where developers come in, they build a handful of homes, they cater to their handful of homes, and the rest of this neighborhood is forgotten about. These families and the children can't walk from one end of this neighborhood to the other without walking in the road. There's developers that come in, and a sidewalk is built for their little piece of the world, and the rest of this community has no sidewalk. There's mention of parks and access to key points. One of the true things of this plan 2035 was sidewalks connecting key things within the community. Someone from the presentation team mentioned the statement of ensuring the design and development of enhancing the character of the existing community. Comprehensive, well-designed neighborhood. Not a single one of those has been addressed here. There's no conversation of, okay, we're going to also connect these sidewalks to actually make the park approachable. Right now, the park in this community that's referred to, there's no paved way to get to the park. You're walking through dirt and mud and grass to get to this supposed park that doesn't truly exist. There's a daycare that is not mentioned that I believe it would be the southwest corner of Lot 1 backs up against. It's also what the sewage area and stormwater drainage is borders up to. That's been a constant problem in this community for years that we've tried to have addressed. WSSC has come in. They built this ugly giant rock structure that is directly butted up against the daycare. It's now overgrown with trees. There's poison ivy all over the place. We've asked countless times for the county to come in and trim and maintain this area, and it doesn't happen. Off of Lot 1 is a huge drop off that's constantly dumping issue. And those things, I think this would help those matters. And it sounds like the family has taken that into consideration. But that stormwater drainage, that area around Lot 1 is a major, major issue. It has been for this area for a while. I am not joined there, but very close by off of that area. And it constantly floods the backyards of those homes. The daycare has no sidewalks. This community, I think an important key here is that the community being proposed, there's no way to get to it without connecting through Vernon Road, Lumar Drive, Gibbons Drive, or Oaklawn Road, all of which are mandatory access roads to get to this property. Their current speed problems, but most of the families don't allow their kids to walk from one side of this community to the other because people speed through this neighborhood. There are speed bumps, but those are not necessarily good or effective. But what needs to happen in a scenario like this, I hate to say this, but if this kind of proposal were happening in some other areas, there would be conversation around sidewalks spanning this whole community, and maybe a bike lane coming in where the families and the children who live here and the daycare has access to safely walk up and down these streets from one end to the other as part of a community and a neighborhood like this coming in. And none of that's, really being discussed. And right now you cannot walk from one area to another on a consistent sidewalk. There's a sidewalk for maybe 2 or 3 homes, And then there's a quarter-mile stretch where you have to walk in the road, and then another couple houses with a sidewalk, and there's nowhere for children to go, and they're constantly on bikes and up and down these roads. Um, the sorry, just trying to catch my notes here. The cohesiveness of the neighborhood is key, and the other part, secondary, that's been stuck on here is the conservation and stormwater. I was happy to see that the staff did disapprove this variance request. I do agree from the sounds of everyone that a reallocation or adjustment of these lots would be beneficial. I understand that it is at a detriment to what the family's looking for, but at the same time, I think it's the responsibility of the county and the board to look out for the community as a whole, not just a single family amongst it. I believe, you know, if I do have an opinion here or to throw an idea out, it's been discussed about lot 6, 7, and 8. From living here, lot 1 would maybe be something to consider. Number one, it has the largest amount of the tree removal that was asked for in the variance. You could eliminate that aspect on the environmental side. It's also exactly where some of these water issues, WSSC comes in. You know, it provides that avenue. Not to mention that lot is extremely steep and would probably not be ideal to build on in the first place. Within those areas, it's already an area that the community has a problem getting maintained and an issue with getting to that WSSC and stormwater management. So lot 1 to me seems like an area that could potentially be addressed and relooked at here on this proposal. At the end of the day, I think that you know, the hope for approval here would be to see something that the developer, I know this is not all of their responsibility in terms of creating sidewalks or street lighting and making cohesive community. I think that's something that the county and the board needs to consider here as well. But I think for things like this to come in and really make this county better is to actually commit to what this plan 2035 says and actually creating cohesive neighborhoods and not just piecemealing one developer's work over another and having a disjointed neighborhood like what this currently is right now. I believe this is an opportunity for everyone involved to make neighborhoods like this truly better. I think that what is being proposed is a great idea. I hope that we can back away from the terminology of compound and make, you know, I don't see where this is a community usage as it's being proposed. I haven't really seen how that is being unrolled to any of us right now. And I think it's important to consider the fact that Vernon Road, Lumar Drive, Gibbons Drive, and Oak Lawn Road are all critical parts to making this project work as being the only access roads to actually get to the proposed community. And if we're not bettering what that is and just adding to the traffic, which is already a problem, I don't see how the community is being bettered by this happening right now, and being proposed long term as well.
Okay.
That's the end of my soapbox.
Mr. Ramey, appreciate your patience, appreciate your soapbox, appreciate your thoughtful comments very much. Thank you. Commissioners, we have no one else who signed up to speak. I'm going to ask for a break, take a 15-minute break right now. So it's 12:08. Let's go till 12:25 and we'll come back. And when we come back, we'll have the opportunity for obviously any questions that we have for staff or for the applicant. Then we'll be able to hear any rebuttal and close from Mr. Rivera. So with that, we will see you all back here at this forum in 12:25.
Okay.
5. We have almost our full complement of commissioners back. Give Ms. Bailey a quick sec to join us. Just to go over where we are, we're on the public hearing for item 5 on our agenda, 4-23015 Loveland. We've heard from staff, we've heard from the applicant, we've heard from the public. We'll go back to Mr. Rivera for rebuttal and close. Before we do that, actually, let's hear from Mr. Rivera, rebuttal and close, and then commissioners, we can deliberate and figure how we want to proceed. So with no one else in the public, Mr. Rivera, I'll turn back to you.
Thank you, Mr. Chair, members of the board, Mr. Warner, everybody. I think I talked to my engineer on the break, so that was a timely break, and I appreciate that. In speaking to my engineer, Ms. Morgan, we think we can accomplish the goal of moving the lots around, redesign, as Commissioner Dorner said, Aldo, Ms. Washington. I know you like the concept, but it's how we get there. And so if we can avoid a variance, because that is the law, then we can do so. So I would like to proper condition that prior to certificate approval of the preliminary plan, the lot shall be adjusted to all be at least 1 acre or more, and that obviates the need for the variance. And then at that point, it's moot. So it's incumbent upon us to do so. I've spoken to my engineer. She thinks she can do it. As she said, they normally have straight lines because you don't want these conflicts. With a family, there shouldn't be conflicts except at Thanksgiving. But be that as it may. But be that as it may, if I could just put that on the record, prior certificate approval, the lot shall be adjusted to be 1 acre or more. That mitigates or obviates the need for the variance, and we are acceptance of all the other conditions.
Okay. That is your
Gary
rebuttal.
Connor, for the record, Mr. Chair, if I may, just a point of clarification in the proper, the 1 acre lots are not required in all cases, only those with conservation on them, correct, Mr. Rivera?
Yes, very good point, Ms. Connor. Thank you very much. Learn something new every day.
Excellent. All right. I think colleagues, there's no one else who's speaking. We've heard from Mr. Rivera. I'll close the public hearing under deliberation. I have to say, it sounds like we have a working plan. Mm-hmm. So if we were to do that, so would we take staff's recommendation and deny the variance, or because it's actually what is before us?
Right.
But it doesn't, we deny the variance, but it's moot because you don't need the variance. Okay. All right. So colleagues, under deliberation, any more thoughts, reactions? We have a working solution.
No, Mr. Chair, I would like Mr. Warner to give a clarification how that condition should be drafted.
Please.
Do you mean the condition or the variant approval of the variance? Because I don't think we have to
approve the variance because it's moot if they're going to have that other condition. I want to know about the way the condition should be.
The proper condition.
Right.
Yes.
Right. So the condition that he's proffering is fine, as he stated it and clarified by Ms. Connor, but you still have an application for a variance that they've requested. So you need to disapprove that along with approval of the preliminary plan, type 1 tree, and the other variance.
Right.
Yeah. Okay. And we're disapproving it because it's moot based upon the condition.
Right.
Well, staff's recommendation is that you disapprove it because it does not meet the requirement.
Okay.
So.
Thank you.
Chair, you're muted.
I'm so sorry. Excellent. Good work, all. If there's no further deliberation, I would look for a motion.
Mr. Chairman, I move that we adopt the findings of staff and approve preliminary plan 4-23015 TCP 1-028-2024 and approve variance to section 25-122B1G and disapprove variance to section 25-121C3, subject to the conditions as outlined in staff's report, to include applicant proffered condition, which was read into the record but relates to prior to certification of approval. Each lot shall have a minimum of 1 acre, and it shall only reference the acreage where the woodland conservation is required. And I would ask legal and staff to make that a lot nicer and neater than I just articulated.
No, that was pretty good, I gotta say.
Second.
Sounds good to me.
Okay, there's a motion. Is there a second?
Second.
We got a motion by Commissioner Washington, a second by Commissioner Giraldo.
Mr. Chair, we couldn't hear you. Were going in and out.
I'm sorry, can you hear me now?
Yes.
Yes.
Just before under discussion, let me just say thank you everybody for your thoughtfulness on this and your creative problem solving and the staff work, and for the applicants, and clearly to the applicant, you've inspired us with what you're trying to do, and we have our role and need to make sure that we follow the laws for the good of the county. So with that, I'll call the roll. Commissioner Giraldo.
Vote aye.
Commissioner Washington.
Vote aye.
Vice Chair Bailey.
Vote aye.
Commissioner Dorner for the last time.
My last vote, go aye.
I'll vote aye as well. The ayes have it 5-0. To the Jameses and Ms. Williams and Mr. Rivera, thank you all. And thank you very much, team, staff, Ms. Connor, Mr. Burke, Ms. Huttendos, Mr. Warner. Thanks to everybody for all the good work on this.
Yeah. Thank you, everybody, for your support. We appreciate it.
Okay. All right.
Thank you and good luck.
Colleagues,
Thank you.
I believe we have nothing else before us in today's agenda. Ms. Connor, am I correct?
That's correct.
Okay, thank you. So without objection, we are adjourned. Mr. Dorner, thank you again.
Thank you.
Thanks,
Thanks, everybody. Take care.
Bye.
Bye-bye.